And you're charged with two cases. You're charged with criminal mischief, and you're also charged with interference with the emergency request for assistance. On the criminal mischief, you're facing up to 6 months in jail and a $2,000 fine. And on the interference case, you're facing up to a year in jail and or a $4,000 fine. I also see she has an open warrant.
Yes, Your Honor. I see that as well.
You also are charged with, I guess, the following day, you picked up a terroristic threat. On that case, you're facing up to 6 months in jail.
A woman stands before the judge, facing not one, but 3 criminal charges: criminal mischief, interference with an emergency call, and just 1 day later, a terroristic threat. Each charge carries serious jail time and thousands in potential fines. And it doesn't end there. The court reveals an open warrant still active against her. The judge, unfazed, lays out the charges with firm voice and sharp clarity. Now, all eyes are on what comes next. Will she take accountability or spiral deeper into the system?
First, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Let's do probable cause and then we'll.
On April 13th, 2025, officers were dispatched to a disturbance. Dispatch stated that the defendant knocked the complainant's phone out of her hand and then left the location. Officers made contact with the female matching the description given by dispatch. The female stated that she was the victim, but she was not talking without a lawyer. Defendant gave name and date of birth, but would not provide an ID card. Defendant was detained and taken back to the incident location. Complainant stated she reported a criminal mischief on the defendant the day prior. Complainant advised to dispatch that he would later call back and report the incident, which he received video of the incident proving that the defendant had damaged his vehicle. Complainant advised today he went to the store, and when he returned, the defendant was on his porch. Complainant asked the defendant, "What are you doing here? After you broke my window of the vehicle, of my vehicle." Complainant advised he told the defendant just to sit there while he called police. Defendant then left, but returned while he was on the phone with dispatch. Defendant knocked the phone out of his hand and caused damage to the phone. The value of the phone was $300.
And what about the terroristic?
So the terroristic threat, Your Honor, and this is the same complainant. On April 15th, officers were dispatched to a telephone harassment. Upon arrival, officers spoke with the complainant. Complainant stated that he had received a phone call from the defendant via a Google phone number, threatening to shoot up her home. Complainant stated she was confident the caller was the defendant and expressed her desire to pursue criminal charges. Further investigation revealed that the defendant had been arrested at the same location on April 13th for interference with an emergency call and mischief. She was out on bond for that incident.
Should be given conditions not to go back.
Let me check here.
Ms. McKnight, I'm going to find that there's probable cause to go forward with the case. I don't want you to have contact with this person.
It's not for them. I'm praying about that person.
I don't want you to have contact with this person. Do you understand? Are you sure? You understand?
Yes, sir.
Okay, I don't want you to go where this person lives. If you do, it's not going to go well. I will revoke your bond, put you in jail.
Yes.
Do you understand?
Yes, sir. I have evidence for all that.
And I'm going to give you a lawyer today. I know that there's two sides of the story. You can give your side of the story you can give your side of the story to the lawyer, but I don't want you to have contact with this person. That's it. Do you understand?
So when it comes down to the child, do I have to come back to court just to get in contact with him?
I don't want you to go to his house.
No, I'm talking about do I have to come to court so I get in contact with him because we have a child.
We'll figure that out. Let me get you the lawyer and then we'll figure that out. But just don't go to the person's house. Don't have contact with him. Don't call him. Don't use anybody else's phone to contact him. It's not going to go well. You need to understand that if I revoke your bond in this case and I set them at $5,000 to $10,000 and you don't have anyone to post those bonds, you will be stuck in there until these cases are over. Do you understand?
Yeah.
Okay. Deputy Miranda, you mind? You know what? Don't even worry about it. I'm going to appoint you a lawyer today. I'm going to have you sign a reset with Victoria, and then we'll have you take a seat in the jury box while I find you a lawyer. Don't leave until you sign our bond conditions. Okay. Good morning, Mr. O'Neill. Morning. Sir, you're charged with terroristic threat of a family or household member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
Good morning, Judge. Just 1 second. Pulling up right now.
Okay.
Sir.
I thought I was supposed to have an attorney here today.
Did you hire one?
No, the judge that I talked to said that I could have.
That was for purpose of magistration, but it doesn't carry with you until the end. You don't have a lawyer at this time.
All right, Judge. On April 12th, 2025, officers responded to a family disturbance call in Harris County, Texas. The officer ID'd the complaining witness by their Texas ID card. The complaining witness stated that the defendant threatened to shoot her. The complaining witness ID'd the defendant by his Texas driver's license. The complaining witness stated that she is the defendant's daughter and they all live together in their grandfather's residence. The complaining witness stated that the defendant threw her clothes outside. The complaining witness stated she asked the defendant to go get them. The complaining witness stated that the defendant stated, "I have something else for you," and then took his hand and pointed it at the complaining witness, stating, "I'm going to shoot you." Complaining witness stated that they were in fear due to multiple guns being in the house and the defendant having a violent history. The complaining witness stated she observed the defendant holding a black long gun. The officer detained the defendant. The defendant refused to ID himself, repeatedly stating, "What is going on?"
Whoa, that just
A woman stands accused of 3 serious charges: criminal mischief, interference with an emergency call, and a terroristic threat, each carrying up to a year in jail. Officers say she knocked a phone from her ex's hand and damaged it while he was calling 911, then allegedly returned days later to threaten to shoot up his home using a masked phone number. The judge makes one thing crystal clear. She is not to contact a complainant. No calls, no visits, no excuses. Even claims of shared custody won't bend this order. The court warns her. Any violation could land her behind bars with bonds too high to pay. She's appointed a lawyer in order to sit down and listen, because freedom now depends on absolute silence and strict obedience. No contact, no games.
Were read. The defendant denied all allegations and stated his daughter, the complaining witness, was lying. Defendant advised that he hadn't seen the complaining witness all day long because she was at the hospital visiting her mother. The officer inquired about this, and the complaining witness stated that she did not go to the hospital. It was only her grandfather who went. The complaining witness stated that she was home, and the defendant did see her and threaten her.
All right, Mr. O'Neill, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you, as a condition of your bond, not to have any contact with this person and not to be in possession of weapons. These are your bond conditions. If you violate these conditions, I will revoke your bond, put you in jail.
Absolutely.
Do you understand?
I don't have.
Just don't say anything at this point. Just don't have any weapons. Don't have contact with this person. There's a protective order that has been issued in this case. I would get to know it. If you do something to violate the protective order, they will potentially file additional charges against you. Do you understand?
Yes.
Okay.
What about the house? That's where all my stuff is at.
What I'm going to do is I'll appoint me a lawyer today. You can talk to the lawyer about what's going on, but I'm going to do everything in my power to protect everybody in this at all costs. You understand? Okay. So look,
She can go wherever she wants. But I'm just asking.
let's do this. Let me appoint you a lawyer. You can talk to the lawyer and we can go from there. Now is not the appropriate time to go through this.
I've been staying at a shelter.
Okay, hold on.
And
I already have an application. So Vic, do you mind appointing him? I already have an application on file. For now, what I'm gonna have you do is I'm gonna have you sign a reset with Victoria while you take a seat in the juror box while I find you a lawyer. We'll have you talk to this person and we'll go from there.
the reset happened in a few days.
We usually do like a month.
Months.
I'm gonna have you talk to a lawyer today. Good morning, Mr. Schaefer. Sir, you're charged with aggregate theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
Thank you, Judge. The officer made contact with the loss prevention officer of O'Reilly's Auto Parts, who stated that he received an anonymous online tip about a possible theft regarding one of the employees from the 3498 FM 528 location. That's an address. The tip stated that the defendant had made 2 fraudulent returns and kept the money from them. The first return was back on August 2nd, 2024 for $316.50 for three brake rotors. The complaining witness was able to contact the customer and they advised they did not return the rotors. The other return was on January 16th, 2025 for $179. The complaining witness contacted that customer and they also advised that they did not return the product. The total of the 2 returns was $495.50. The defendant admitted to the theft in a written statement. Complaining witness provided the 2 fraudulent receipts and listed on each was Schaefer's unique counter number.
Okay. Mr. Schaefer, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have contact with this O'Reilly. There's not a specific complaining witness, right? So I'll just go into O'Reilly's. Do you understand?
Yes, sir.
Okay, if I find that you do, if I find that you pick up a new case, it's not going to go well. Do you understand?
Sure.
Do you have the ability to hire a lawyer?
Sure, I can do that.
Okay, we can have you fill out an application. I'll look to see whether you qualify. Deputy Miranda is going to give you an application. I'll have you go to Victoria, sign a reset. We'll have you take a seat. We're losing spots.
I only got one more minute and I'm supposed to.
Okay, well, there's one.
Bond conditions you gotta sign.
Okay, so we'll do all that. We'll have you take a seat there and then let me start. Okay, please.
I'll just call up the next one that could be ready. Go ahead and sign. Theo, come on up.
So you're charged with evading arrest or detention and theft. On the evading arrest, you're facing up to a year in jail and or $4,000 fine. On the theft, you're facing up to 6 months of jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 11th, 2025, officers were dispatched to a theft in progress call in Harris County, Texas. Officers were given a description of the defendant by an Academy employee. The officers observed the defendant walk out of the store passing all points of sale. The officer attempted to detain.
Mr. O'Neill stands accused of threatening to shoot his own daughter during a family dispute. The daughter claims he pointed a long gun at her and made the terrifying threat. He denies everything, saying he never even saw her that day, but her account and the officer's report say otherwise. The judge rules there's enough probable cause to proceed and lays down strict orders. No contact with the alleged victim, no weapons, and absolutely no violation of the protective order now in place. Any misstep, and O'Neill will find himself behind bars until trial. No questions asked. In True 4, a teenager tried to escape after stealing a paintball gun, running over 1,200 feet before tiring out and getting caught. In court, the judge warned him to focus on school. That's your real full-time job. In another case, a young man assaulted his own sister during a heated argument and now faces assault charges and mandatory drug testing. Meanwhile, a suspect behind the wheel of the stolen car led police on a dangerous chase, nearly hitting an officer before crashing and getting arrested, prompting the judge to impose GPS monitoring, curfews, and a sharp warning. Stay out of my city or you'll be stuck like Chuck. One defendant, worn down by the system, rejected probation and chose conviction, despite knowing it could follow him for life. The judge urged him to think long-term. It's not about punishment. It's about purpose. In a final moment, the courtroom turned reflective as the judge reminded everyone, driving isn't a right. It's a privilege. Earn your freedom with discipline,